Welcome back to another episode of Spilling Secrets, a podcast on all things related to trade secret and non-compete law. My name is Dan Levy, and I am a partner in Epstein Becker Green's Newark, New Jersey office and member of EBG's Trade Secrets and Non-Compete Subpractice. Today, I am pleased to welcome a new contributor to the Spilling Secrets podcast, my colleague Gianna Deneau. Gianna also works in the Trade Secrets and Non-Compete Subpractice and is also located in our Newark, New Jersey office. So we have an all-New Jersey team, I think for the first time on Spilling Secrets, but I promise we will try to keep our references to exits on the Garden State Parkway and to the Sopranos to a minimum. Gianna, welcome to Spilling Secrets.
Thanks for the introduction, Dan. It's a pleasure to be here.
Today we are going to discuss the workshop hosted by the Federal Trade Commission on January 27th of this year that the FTC titled Moving Forward, Protecting Workers from Anti-Competitive Non-Compete Agreements. The workshop was informative on many levels, including how the FTC will view non-competes under the Trump administration and how those views differ from under the Biden administration. By way of background, the FTC initially scheduled the workshop in November 2025, but it had to be rescheduled due to the government shutdown at that time. So the FTC eventually rescheduled it for January 27th and made it entirely virtual as a result of a snowstorm in DC that week. That being said, both Gianna and I attended the half-day workshop. So Gianna, I'd like to start by asking you to give a brief overview of the FTC's role in relation to non-competes.
So the Federal Trade Commission was created in 1914. Its mandate was, and remains, to prevent unfair methods of competition and unfair or deceptive acts or practices affecting commerce. For decades, non-compete agreements were largely regulated by state law. States like California broadly prohibited them, while others permitted them so long as they were reasonable in scope, duration, and geography. Yet, beginning in 2023, the FTC made its first attempt to regulate non-competes on a nationwide level.
And as our listeners know, we have discussed at length on this podcast and in our Trade Secret and Employee Mobility blog, the FTC's proposed non-compete rule from 2023 and the subsequent litigation. Gianna, can you provide a very high-level overview of the non-compete rule and what the status of that rule is today following the FTC workshop?
So, under the Biden administration, the FTC proposed and in April 2024 finalized a sweeping non-compete rule that would have effectively banned most non-compete agreements nationwide. The agency at the time concluded that practically all non-competes constituted an unfair method of competition under Section 5 of the FTC Act. The rule would have invalidated existing non-competes for most workers and prohibited employers from entering into new ones, with only a narrow exception for certain senior executives. It was essentially a categorical ban grounded in FTC's then Commissioner Khan's interpretation of its rulemaking authority. However, employers almost immediately filed various lawsuits, and the federal courts quickly intervened. Multiple legal challenges to the non-compete rule argued that the FTC had exceeded its statutory authority, that Congress had not clearly authorized the agency to promulgate a rule of this magnitude affecting the entire national workforce. The legal challenges worked its way up to the circuit courts, and ultimately, in September of 2025, under the Trump administration, the FTC voluntarily dismissed its appeal. And during the workshop, FTC Chairman Ferguson made crystal clear that the non-compete rule is eradicated under the Trump administration.
So the notion that the non-compete rule is dead following both court opinions and under the Trump administration does not really come as any surprise at this time, particularly given that Chairman Ferguson authored a powerful dissent in response to the non-compete rule, arguing that the FTC lacked the statutory authority to make such a broad sweeping rule. If the non-compete rule no longer exists, Gianna, I'm interested to hear your thoughts regarding what the FTC's policy will be respecting non-competes under Chairman Ferguson's FTC.
Of course, so there's a shift. So the workshop was not about resurrecting the Biden administration's non-compete rule. It was about defining a new path. So under Chairman Andrew Ferguson, the commission signaled a pivot. And rather than pursue sweeping rulemaking, the agency will now rely on a case-by-case enforcement using its existing statutory tools. Chairman Ferguson further emphasized that while the prior administration may have overreached in attempting a nationwide ban, it's important to note that the FTC is not retreating from the field. Instead, it plans to scrutinize non-compete agreements individually, bringing enforcement actions where it believes the agreements function as unreasonable restraints of trade. The shift is important. It reflects a broader regulatory philosophy under the Trump administration: less categorical rulemaking, more targeted enforcement. Rather than declaring non-competes unlawful per se, the agency is signaling that some non-competes may be defensible, but only if they are genuinely necessary to protect legitimate business interests and narrowly tailored to do so. During the workshop, the FTC, whether expressly or impliedly, focused on three main categories for enforcement. The first was the healthcare industry, then industries that traditionally do not have a sufficient business justification to support non-competes, and lastly, low-wage employees. We'll dive deep into each, starting with the healthcare industry.
Great. Thanks, Gianna. That is an excellent overview of the FTC workshop. So while the FTC expressly stated that its enforcement actions moving forward would focus on low-wage employees and those industries that may not traditionally have a legitimate business need for non-competes, I want to discuss what I believe will be a significant area of focus for the FTC under the Trump administration, and that is non-competes in the healthcare industry. And I think it's important to note that the FTC did not come out specifically and say they are going to be watching the healthcare industry during the FTC workshop. But what I found to be interesting was the number of panelists that the FTC invited were specific to healthcare, including physicians, veterinarians, and other allied health professionals. Furthermore, the use of non-competes in the healthcare industry has traditionally been a focus of the FTC. As recent as September 2025, the FTC sent warning letters to several large healthcare employers and staffing firms, urging them to review employment contracts, including non-competes, to ensure that they are appropriately tailored and lawful. Those FTC letters emphasized its concern that overly broad non-competes for nurses, physicians, and other medical professionals can limit employment options and could also reduce patient choices. Also, in September 2025, the FTC launched a public inquiry to gather information on non-compete practices to inform future enforcement actions. Chairman Ferguson also made it a point to cite to the FTC antitrust action involving U.S. anesthesia partners, where the FTC alleged that a healthcare and technology company engaged in anti-competitive conduct to suppress competition and increase prices in the anesthesiology industry. Considering the background of the FTC's 2025 actions and the number of healthcare panelists speaking during the workshop, I think it's very reasonable to conclude that the FTC will be scrutinizing healthcare non-competes in 2026 and moving forward.
That's a great overview, Dan. So, what should healthcare providers do in response to the likelihood that the FTC will focus on the healthcare industry?
I think it's important for healthcare providers to examine their non-competes now and determine whether they are reasonable, specifically looking at the geographic scope of the restraints. Essentially, employers must take into consideration whether the restrictions are being used to legitimately protect their legitimate business interests or are being used simply to prevent competition. For example, if a non-compete is structured based on where the healthcare provider physically practices, that may in fact be a legitimate business reason if the scope, time, and geography are all reasonable. However, if the geographic scope of the non-compete is a radius from every single facility that healthcare provider owns or operates, then that is likely unreasonable and unenforceable. It is important for providers to look at their agreements as well as to potentially make revisions to their agreements for future hires. It is likely that the FTC will remain skeptical if the non-compete impacts a patient's choice or to go to a physician of their choosing. So that's the update as it relates to the healthcare industry. Gianna, can you enlighten us with the other industries where the FTC may focus its enforcement efforts in the non-compete space?
So there's a second theme emerging from the workshop, and its focus was on industries where non-competes appear unnecessary rather than essential. So the agency discussed enforcement activity involving companies and service industries, including businesses where employees may not typically possess trade secrets or proprietary strategic information. In one recent enforcement action, Gateway Services, the FTC challenged non-competes imposed on employees of a pet cremation company, arguing that the year-long industry ban for workers bore little connection to any legitimate business justification. So in November of 2025, the FTC entered its final order where it stated Gateway is required to stop enforcing existing non-compete agreements specified in the order and is prohibited from entering into similar agreements moving forward. The message is clear that the FTC is skeptical of boilerplate non-competes imposed across entire workforces without differentiation. If an employee does not have access to confidential information, trade secrets, or customer relationships that require protection, the Commission is likely to question why a non-compete is necessary at all. The agency appears poised to ask, what is the actual competitive harm being prevented, and is the restriction proportionate to the risk?
That's very interesting. So, Gianna, do you think that it's limited to a pet cremation company, which seems to be a quite specific industry, or might there be specific industries that also might be in play, or is it kind of a case-by-case issue as to a specific employer?
I think it's going to be a case-by-case issue here, but also we have to really focus on whether or not that industry has access to confidential and proprietary information. Another example discussed during the FTC's non-compete workshop involved the worker in the hair care industry. So panelists highlighted how non-compete agreements can be particularly burdensome in industries like hair salons, where protecting confidential information usually isn't a central business concern. In the examples shared at the workshop, a hairstylist was bound by a broad geographic restriction that prevented her from working anywhere near her home after leaving the salon. And as a result, she faced the difficult choice of relocating, and challenging the agreement in court would have been overly expensive. So the story illustrates that the FTC's broader concern that non-competes in certain industries, especially those with limited proprietary information, can restrict worker mobility without serving a legitimate business purpose.
I think hair salons is a pretty good example. I know that there is also an example, even though the FTC didn't specifically cite it, regarding Jimmy John's and whether the making of a sandwich constitutes confidential or proprietary information.
Yep, that's definitely another example.
And I think those, and that one in particular, leads to and segues well into the final category where we are likely going to see increased enforcement actions under the FTC.
So the third major enforcement focus that we had previously mentioned is non-competes for low-wage, hourly, or entry-level workers. Panelists at the workshop emphasized that non-competes affecting janitors, retail workers, interns, or part-time employees often lack any credible business justification. Instead, they may function primarily as a retention tool, and one that restricts worker mobility and suppresses wage growth. So this concern mirrors legislative trends at the state level, where many states now prohibit non-competes for workers earning below certain salary thresholds. Although the FTC's nationwide ban was blocked, the agency appears intent on aligning its enforcement strategy with the state's current policy movement. So in the FTC's view, non-competes applied to lower wage workers with no access to confidential strategic information are likely to be viewed as inherently suspect.
So I think that in summary, although it's not at all a surprise that the non-compete rule is eradicated under Chairman Ferguson's FTC, it does not provide a full pass for employers. First, employers must ensure that the non-competes comply with state law, because nothing addressed by the FTC relates to state requirements for non-competes. And also, employers must continue to ensure that their non-competes are narrowly tailored and support a legitimate business justification that is not simply to prevent competition. Gianna, any other final thoughts?
I completely agree, Dan. Employers should really take the time to review their non-compete agreements and ensure that they are compliant with the current legal landscape, paying particular attention to the industries that we just discussed, where these issues will be especially significant under the current administration.
Excellent. Thank you so much, Gianna, for joining us today. And thank you, everyone, for tuning in to another episode of Spilling Secrets. Until next time.
This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.